Donald Trump criminal trial in New York is right around the corner, and both sides are filing their motions. Donald Trump submitted a motion in limine. This is a preliminary motion. It has a lot of stuff in it, and we'll hit some of the highlights. But the main thing that Trump is asking for is that Michael Cohen's testimony be precluded, that he be banned from testifying, because he's a convicted perjurer. Guy has a long history of lying, flip-flopping all the time, lied to Congress, has a criminal conviction for it. And so why should he be allowed to testify if he's not a credible witness? Now, the way this works oftentimes is the judge will allow them to testify, and it's up to the defense to impeach their credibility and to say, aren't you a liar though? And so we're gonna have a lot of this, but what is the main takeaway is Trump is trying to frame this out and say he should not be allowed to testify about these avenues or limited in these ranges. And so we're gonna see what's inside. We'll see what CNN says in response and remind ourselves, we've got trial coming up here, March 25th, 2024. We're gonna be covering it as in-depth as humanly possible. We do not know yet whether they're gonna have a live feed for us or not, but we're gonna be here covering it. Even if we have to do X scripts or translate what's happening in court, we'll do it. So thanks for subscribing and joining us when that comes up. Now, this is the motion in limine, and it is from Donald Trump, and you'll notice it's a big one. It's a 47-pager filed February 26, as the trial is now on the docket. It's heating up, and we're going to be starting jury selection in just a few short weeks. So this is the case. The people of the state of New York, a criminal trial now, a felony, multiple felonies against Donald Trump. This is Trump's motion in limine, and it's a preliminary motion meant to define the scope of the trial. What are we going to get into? What are we not getting into? So they tell the judge, and this is Judge Juan Mercan. The case is Alvin Bragg Prosecution. They say, all right, dear judge, we know this judge is not a favorable judge so far. Says, all right, dear Judge Juan, Trump respectfully submits these motions. These are motions in limine, and we're seeking pretrial rules about improper arguments and inadmissible evidence that Bragg appears to wants to offer in this trial. And they're trying to do this to bolster their listless zombie case, right? This case has been around forever. It's a 2016 problem. And their unsuccessful efforts to interfere with Trump in 2024. So it sounds like Bragg is trying to shove a bunch of stuff into this case that does not matter. It's not relevant to the underlying issue. And specifically, Trump is seeking rulings on the following. Says Michael Cohen should not be allowed to testify. They're going to be bringing out additional perjury if he does. Also, any of this election influence stuff should be precluded. Shouldn't be allowed to argue that Trump sought to improperly influence 2016 because there was nothing untoward or irregular, and there was certainly nothing criminal about his winning a candidacy when millions of Americans voted for him. Saying there shouldn't be any improper intent to defraud arguments. Saying Bragg should also be precluded from arguing this because Trump intended to win 2016. He won it well within the established norm. So that's not intent to defraud. Talking about bootstrapping and other inadmissible evidence. You see, they give us a nice summary of it all, but let's get into the conversation about Michael Cohen here. And Trump's team not playing around with their first sentence. Why would they? They say, first of all, Your Honor, let's be clear about this. Michael Cohen is a liar, period. Beautiful. Very simple, direct and to the point. A+, well done. And actually factually true. Michael Cohen is a liar. He recently committed perjury on the stand and under oath at a civil trial involving President Trump. And if his public statements are any indication, Michael Cohen, the perjurer, he plans to do so again at this criminal trial. Now, the court should preclude Michael Cohen's, the liar's, testimony in order to protect the integrity of this court and the process of justice. They say, first of all, Judge Juan, Cohen's demonstrated record of lying, it ranges from minimizing his criminal conduct and distorting his background in public statements to the media, that's the minor stuff, to the very serious and the consequential perjury that was committed in New York versus Donald Trump in a 2022 case. Now, even before his federal sentencing for lying that occurred in 2019, Michael Cohen began to, quote, minimize the seriousness of his decision not to report millions of dollars of income over a period of years by blaming his accountant for not uncovering the reported income. Guy grifts millions of dollars. Like, oh, my accountant screwed it up. Yeah, right. And then we get a big bunch of redactions, which irritates me. Michael Cohen's a liar and a loser, and he did a bunch of other loser things. Now, in 2019 December, less than 1 year into his 36-month sentence for federal crimes, including tax evasion, crime of dishonesty and moral turpitude, and lying to Congress, Cohen then sought a sentence reduction. Yeah, and prosecutors in the Southern District of New York, they opposed that motion. The prosecutors from New York, where we're at right now in a different court, this is federal court, they opposed that. They informed Judge Pauly. They said, no, we had substantial concerns about Cohen and his credibility as a witness. Okay, dude's a liar. Based in part on lies that he told during proffers that included material false statements, like lying to the court, violations of federal law in January and February of 2019. Now, the federal prosecutors, when talking talking about Michael Cohen, they also express concern about apparent contradictions between Cohen's post-sentencing congressional testimony and his guilty pleas and certain filings in the Southern District of New York case. So in other words, the dude has already been sentenced and convicted, and he's still lying, okay? So they're still talking to him post-sentencing, lying in his guilty pleas, lying in other filings, and a litany of other public comments made by Cohen and his surrogates concerning his federal case, many of which, right, he's on podcasts. He's like BFFs with Jen Psaki now. They're having conversations, and he's like, well, I had to take it. I had to do this. I never made that, right? He's a victim constantly. Many of which minimized his acceptance of responsibility and were inconsistent with his guilty pleas and other undisputed facts. And remember that Cohen also used Bard, ChatGPT, to fictionalize case law and submit that to the court in another case. I think it may have even been this case that we're talking about here. And yeah, you know, that's just Cohen status for you. Now, they say last fall in New York versus Trump, Michael Cohen committed perjury. Again, he testified that he was not guilty of the federal tax evasion charges to which he pleaded guilty to. So he lied on the stand, and that he lied to U.S. District Judge William H. Pauley III during his sworn plea allocution in 2018. Lied again. Now, this included the following sworn testimony regarding his guilty plea. So in other words, he says, right, I actually was not guilty. And so when I took a guilty plea, when I pleaded guilty, part of what you do in a guilty plea is you say, yes, I'm guilty. So the crime is whatever it is, tax evasion, perjury. How do you plead? Guilty. And then you have what's called a factual basis. Conversation about what happened. I, Michael Cohen, on this date and time in this location, yes, I committed this crime because I did the following. I lied to Congress. What I said was not true. And the attorney will say that, the prosecutor will say that, the judge will sometimes say that, confirm that. Is that true? Yes, it is. Okay, great. I find there is a factual basis for your guilty plea. So I can accept that. Because if somebody says, I plead guilty, and then they lay out the factual basis for the reason you're pleading guilty, and you say, no, that never happened. Well, the judge is not going to accept your plea. So this included the following sworn testimony regarding his plea. Question: have you ever made any public statements concerning the legitimacy of your convictions? More than one. And why did you do that? Because there was no tax evasion. Now, at best, it could be characterized as tax omission. I have never in my life not paid taxes, says Cohen. I have never requested an extension until 2017. Every year I had paid. No extensions on time. I paid what my CPA accountant directed me to pay. Wow. So apparently that was the question to him. And the response at another part of the transcript was, okay, so did you lie then to Judge Pauley when you said that you were guilty of the counts that you said under oath that you were guilty of? Did you lie to Judge Pauley? He says, yes, I did. Wow. So, sir, you lied at the time. You lied more than once in federal court. Is that correct? Correct. So when the stakes affected you personally, you lied, right? Correct. And you also misled a federal judge. Is that true? Yes, I did. Wow. So Cohen is just lying all the time, right? So he lied about being guilty of lying. Amazing. So Cohen committed perjury again. In other words, they brought him to the stand and he's just lying again when he falsely testified that he refused a motion pursuant to the rules from the U.S. attorney, Michael Cohen. Question: and Michael, did you attempt at any point to cooperate with the government in connection with your guilty pleas? He says, yeah, I did cooperate with the government. Yeah. However, you did not receive 5K1 or substantial assistance letter from the federal government, did you? You didn't get a letter like confirming that? No, I refused a letter. Okay. Well, they say that's not anything that happened, okay? There was no such motion. There was no agreement to make a motion. Nothing was ever extended to Cohen. Federal prosecutors have also taken the position that Cohen lied under oath. So simply put, okay, Judge Juan, the federal government acknowledged what the people in New York, what Bragg, okay, will not, is that Cohen is not a truth teller. He is a serial liar. And Alvin Bragg knows that. Even the federal prosecutors know this. They say he's lying to us. They put it in their footnotes. SDNY's opposition, okay? So when Cohen was saying, can I please terminate my probation early? They said, no, dude, you're a liar. Get out of here. And there was multiple citations to that, okay? So federal prosecutors know this guy's a dirtbag, not credible at all, just like the rest of the prosecutions. And Alvin Bragg's like, he's my guy. He's my go-to. Let's go get it. So they say, Your Honor, these prosecutors, okay, the people, which offends me, like they represent the people, get out of here. The people, the government, Alvin Bragg, are officers of the court, right? They're charged with ensuring that testimony presented to judges and juries is truthful. They have a sacred obligation to call only witnesses who are supposed to be truthful. Now, as referenced above, federal prosecutors, in this case, in our own government, have taken the position that Cohen, quote, appears to have lied under oath in a court proceeding. And he's going to be their star witness. Strikingly, Cohen has also admitted to lying in court. A lie is a lie, no matter what its subject. And if it is in any way relevant to the case, the DA has the responsibility and the duty to correct what he knows to be false and to elicit the truth. In response, They say here, perjury is material if there is any reasonable likelihood that the false testimony could impact the jury. Now, in response, Cohen's own attorney was forced to try to twist his false and sworn words. He suggested that Cohen's testimony, although clumsy and poorly worded, did not dispute the basis of his guilty plea. That's not what we just read, okay? You lied to a federal court, correct? Correct. So you lied. Okay, I admitted it. Yeah, I'm not guilty of what I said I was guilty for. I lied to the judge. Okay. His lawyer's like, nice try. Now, the DA, Alvin, is the representative not of an ordinary party to a controversy, but they represent the government. The duty is, in a criminal prosecution, is not that it shall win a case, all right? This is all like evaporated now. So pre-Trump, I felt like it was more true, certainly more true than it is now. What we have now is just get Trump at all costs. It shall win a case. It should have been, but it's that justice shall be done, right? Prosecutors are supposed to care about justice, not convictions. When it comes to Trump, they don't really care about anything other than a conviction, including the Constitution, due process, 234 years of historical precedent, whatever. Now, they say, given this clear evidence, okay, Judge 1, that Cohen perjured himself in his testimony at the most recent case when they brought him up to the stand, and the likelihood that he's going to commit perjury again if he's called by Bragg in this case, it was disturbing to hear the people, Bragg, blithely proclaim that at the February 15th hearing at the conference that his perjury is not their problem, right? It's not our problem if he's a liar. And that could be addressed by the defense on cross-examination, which is generally how this works. When generally, actually, prosecutors don't put liars on the stand, even cops and stuff. Like, man, that cop has like a Brady list file. It's like not good. So they don't want to put liars on the stand because you'll obliterate them. But they don't have anyone else in this case, right? He is their star witness. He's the only real witness that's going to connect all the dots here. And the dude is a liar. So they're trying to get him out now. I think the judge is, of course, going to let him on, obviously. They would have no case if he kept him off. So they are going to have to address it on cross-examination, and that's generally the rule. But you also generally don't see a situation where they take a convicted perjurer who admits, like on the stand while he's testifying, that he lied. Prosecutors generally have more sense than that, but we're operating in bizarro world and New York. So they say Alvin's desire to rush ahead with these proceedings rather than look into the ongoing criminal conduct of their star witness, Michael Cohen, is troubling, and it violates the people's ethical and constitutional obligations. And the people, Alvin's failure to live up to their obligations, it requires this court, you, Judge 1, to step in and preclude the people from suborning perjury by calling Cohen as a witness. And so we're going to see what, obviously, Judge 1 does about this. I think we're going to see Michael Cohen come in and testify. And we're going to see what Trump and his team does to obliterate him. Now, remember, in the prior trials, when Michael Cohen was brought in particular, in the Letitia case, he was believed, okay? Judge Engeron says, I believe Michael Cohen. So that's the first part of this motion in limine. Let's hit some of the other highlights here. You see, Trump is also trying to stop Bragg from arguing that he sought to influence the 2016 election. They're saying because Trump made all these payments in order to get elected, and that caused a conspiracy. They say, first of all, the charges that Alvin is choosing to bring, they relate to records in 2016. That's when the records are. So they chose to proceed on substantive counts, and there is no conspiracy alleged. However, their submissions to this court, we can see what they're trying to do here. There is an extraordinary effort to prejudice this jury. They're trying to include salacious and irrelevant details from years before the entries in question. Now, to ensure a fair trial, the court must limit this and to offer proof that is only relevant to the case. Now, the court should preclude Alvin from suggesting that Trump sought to influence the election. Why? Because even if the people's evidence comes in exactly as they hope, with perjury and all coming from Michael Cohen, they will at most have a basis to contend that Trump was campaigning, that's all, successfully, as many others have done before him. Now, essentially, Alvin is arguing that efforts by a candidate to prevent adverse publicity about himself equals an attempt to defraud. And this argument has no basis in the law, and it's an extraordinary perversion of our election system. Now, candidates are not required to disclose everything about their personal life, and an attempt by a candidate to keep certain matters personal are neither inappropriate nor illegal. And so Trump and his right to a fair trial requires that they be precluded from bringing in these allegations that would cause false and unduly prejudicial beliefs and cause the jury to be prejudiced. Now, they say these considerations don't change. An elected official concealing damaging information, it's not probative of criminal intent. It's politics. And they cite Biden as historical precedent. They say Biden's suppression of the nature and the extent of his mishandling of the classified information prior to the release of Robert Hur's report is a recent example. And remember that? Remember Biden's sent his lawyers over to clean all this up before they even told us about it? It's certainly not the only one and is a practice as old as politics itself. So no one at Trump's trial should be permitted to assail him him by suggesting to the jury that trying to avoid negative press is an element of intent to defraud. That is the opposite of the truth. Now let's see what else is inside here. So they're talking about this intent to defraud, and they're also trying to keep out some of the Access Hollywood tape and some other stuff. Let's see what that says. They also want to preclude testimony from this person about Karen McDougal. Apparently this person may have been involved in some transactions, and we see some redacted paragraphs here which are curious. They say, contrary to Bragg's suggestion, they say Cohen was intimately involved. Contrary to this, Karen McDougal was with AMI, and remember, AMI was another entity that apparently got some hush money or something. We don't see what's inside of that. So they're trying to stop some of this from coming out at trial. Similarly with testimony from Clifford. Now here's some interesting language. The court should also preclude testimony from Clifford. It's unduly prejudicial. Bragg agrees this testimony is the very best peripheral. They say that the case against Trump, the core of it, is not money for intercourse. Clifford also apparently publicly stated that she will testify at the upcoming trial. She said, I've been asked to kind of behave. You know, I'm biting my tongue so effing hard right now. This person called Clifford. Tellingly, so-and-so and so-and-so reveal that blank would use the trial as an opportunity to promote blank and to monetize blank's story. What is that? That's like 3 characters. So it's like maybe his or her. So they're just trying to hide the gender, really. Reveal that she or he would use the trial as an opportunity to promote blank and monetize her story. Yeah, so that's a different person. Yeah, so this person, and have included her on the witness list. Interesting. Anyways, similar to Cohen, she seeks to tell contrived stories. Okay, another witness. Salacious details of events she claimed occurred 20 years ago. In warning Clifford, Bragg appears to have recognized the risks of presenting this irrelevant and untrue testimony by warning their witness, and they're trying to secure a conviction by dragging her in. Now, we note that Bragg have also produced something, and something. What is that? Ooh, the ex parte polygraph test was administered in 2011, 8 years before Bragg impaneled their juries to investigate Trump, with the only last returning charges on this zombie case. Now, the test, apparently a polygraph, was wholly unreliable. It was privately arranged and unilateral, and it was designed to produce obvious results to support Clifford's public narrative. Moreover, it's inconsistent with statements Clifford has made in denying the affair. Here's the Access Hollywood tape. So Trump says, we got to keep this precluded. Why? It appears that Bragg is going to seek to argue at trial that adverse publicity about the Access Hollywood recording in October 2016, that it somehow prompted AMI executives to notify Cohen about Clifford's well-worn allegations. Now, the contents of the recording of the Access Hollywood, that's the grab by the purse tape, they're not connected to Clifford or McDougal. And because there will be no dispute about the contact or the resulting connection between Cohen and Clifford's attorney on October 10, 2016, the inference that the people seek from the purse tape has only de minimis probative value, and they're just trying to make Trump look bad, in other words. On the other hand, the contents are extremely and impermissibly prejudicial. So much so that even Judge Kaplan reasoned that the Access Hollywood recording was a confession, right, is what he said. So to state the obvious, we disagree with Judge Kaplan, another New York judge. That's the federal E. Jean Carroll case. Trump saying, you know, I grabbed them by their purses. He's like a confession to doing it in Bergdorf's with E. Jean. Okay. Now, Billy Bush, a longtime correspondent for NBC, who was with Trump at the time, commented, says there were 7 other guys present on the bus at the time, and single one of us assumed we were listening to a crass stand-up act, right? No one even believed it. Locker room talk. But the found that Kaplan says that it was an admission, right? They're saying Kaplan calls it an admission, and so that means that it's like evidence of a crime, and that has nothing to do here. The contents have no place in a fair trial on the charges that have been filed here, right? So they're charging him with document crimes, right? Moving money around unlawfully. And they're going to try to, you know, like attach an assault bit of evidence into the whole claim. So don't allow the court to permit these ridiculous arguments. The alleged payments to McDougal and Clifford did not violate the law. They say Bragg, right? Even if these payments were made, they don't violate the law. Now, Alvin Bragg intends to introduce testimony at trial to support their flawed legal theories that these payments were illegal campaign contributions, crux of the case. And thus they satisfy the quote, other crime element for a felony violation under New York law. Like this case is very old, obviously. So they have to find a way to make it a felony so that the statute of limitations is met, and they have this like new theory, and we're going to see how it unfolds for them. However, they say the alleged payments to McDougal and to Clifford, they would not constitute violations just as a matter of law. Why? They were not campaign contributions as defined by federal campaign finance law. Now, as discussed below, courts have found payments much more closely related to campaign advocacy to fall outside of the statute's scope. So here's their argument. They say a third-party payment can be considered a contribution or an expenditure subject to FECA's requirements in 2 circumstances. circumstances. And they detail those for us here. They say a third-party expenditures made, or two, a third-party payment for personal use. Now, it should go without saying, something cannot be an illegal campaign contribution unless it's first an expenditure or a contribution. Now, the payments at issue in this case cannot have violated either of the provisions. Why? One, they were not expenditures, and they were not made for the purpose of influencing any election. And they were also not contributions, as they would have been made irrespective of Trump's candidacy, right? So Trump was going to solve this whether he's running or not. In other words, these payments were not campaign contributions within the meaning of FICA, and thus cannot have been illegal campaign contributions. So the people should not be permitted to present arguments suggesting otherwise. None of these payments were made for the purpose of influencing the election. They give us some Supreme Court analysis on how to interpret those, and the meanings are out of alignment with this case, talking about the DC Circuit. But here, all of that precedent, here, when viewed objectively, the alleged payments to McDougal and to Clifford, and what is her real name? Stormy Daniels? I can't remember. Were not campaign related, and thus were not made for the purpose of influencing the election within the meaning of the law. Neither AMI nor Cohen worked for the Trump campaign, and the payments did not fund the core political activity. And such as advocating for a client or otherwise relieve any financial obligations to free up the campaign's own resources for other expressly political activity. Stephanie Clifford is the name. Thank you. Stephanie Clifford, that's her. So by any measure, these expenditures were far less related to an election than those at issue in Orlowski, which the DC Circuit refused to deem contributions subject to the FEC's limited spending limits. So for this reason, all expected testimony that the payments at issue were made with the subjective purpose of influencing the election, like Trump intended to pay her off, even if credited, is beside the point. The agreements with McDougal and Stormy under the objective test were not campaign expenditures. They say even before Trump was elected, Trump was the head of an extensive business empire. It operated businesses around the world, most of which bear his name. He's got a wife, he's got 5 children for whom he cares deeply. Now, in light of these significant personal and business interests, accounts of alleged interactions, they pose the risk of reputational damage to President Trump and his family and his business interests. All that is separate and apart from his candidacy. Gotta wrap these things up anyways. Thus, even assuming that they entered into these transactions to protect Trump's reputation, the requisite nexus to campaign activity is lacking. You can't show us for campaign purpose. Actually, for the contrary, a contrary view that these sort of payments are campaign contributions, it would lead to absurd results. Simply put, if the payments to McDougal and Clifford were, as a matter of law, if they were considered to be made for influencing an election, that would necessarily mean that campaign funds could have been used to make those hush payments. And that is because, as discussed above, they use identical language between contributions and expenditures. So if you apply the rules they want you to, then everyone's going to be using their campaign money to pay off these types of interactions. Now, one need not be particularly cynical to believe that if these payments had been made from campaign funds, Alvin would be taking the position that the spending, right, if they were classified as campaign funds, he would have been charged for that. They would have said that was unlawful conversion of these funds. And while they did find, the FEC did find reason to believe that the payments to McDougal violated FICA, and Cohen pleaded guilty to FICA violations, no appellate court has ever held that third-party payments of this sort violate FICA. Neither Cohen nor AMI ever even chose to litigate those things, and so we submit that none of these violated FICA, and so Alvin Bragg should be precluded from making this argument. Now they say, again, Trump would have made these arguments anyways. Trump would have paid these things off, and there's other historical evidence of this. For example, the FEC unanimously dismissed a complaint for a $96,000 by a senator's parents of the family of a former campaign worker who also had an affair. In short, the test is whether the third-party payment objectively affected the candidate's ability to campaign. And clearly, that didn't for Trump. The payments to Trump by McDougal and Clifford, by any objective measure, did not materially free up Trump campaign money. Campaign was already well funded, $38 million in cash on hand, more than $50 million, more than $15 million by mid-October. Trump's a very wealthy individual as well. And so this was not a campaign contribution. It did not meet the nexus that's required under the rules. And so they want Alan Weisselberg's notes to be precluded. They say Alvin Bragg is going to try to get in the CFO's handwritten notes, but he's not on their witness list. And the notes are inadmissible hearsay, and they don't have any testimonial foundation from him. They're unreliable, and they should not be allowed in. And here's looks like a picture of his notes or something. Accordingly, it's not admissible. And so get it out of here. And they say, nearing the end, they say, finally, all evidence about Rudy Giuliani should be precluded. They say Trump also moves to stop Alvin from bringing in videos or transcripts or other derivative testimony from Rudy Giuliani about any payments here. They're inadmissible hearsay. They don't follow the rules. individuals, and Giuliani was neither authorized to make statements and questions, nor was he acting within the scope of an existing employment or agency relationship. Now, even if the statement were admissible, which they're not, the people should not be allowed to cherry pick portions that are taken out of context. And so here's some more examples. Rudy Giuliani showed up on Hannity. He was talking about Mueller. Giuliani went off script, said some things that they don't think are admissible. It's not Trump's statement, so don't let any of this in, right? Rudy's out there just, kind of running his mouth a bit. They're like, well, we didn't authorize him to say that stuff. So these statements should be precluded. They try to introduce 100 statements that they're trying to attach to Trump. Approximately 4 dozen excerpts come from Trump's book, some published nearly 40 years ago. And so they're trying to introduce all of these statements, even like this from Trump, like think like a billionaire. Now, the people should not be allowed to introduce this stuff, whatever the style of his business operations were in 87, 2004, 2007, when these excerpts are written. There's no means for trying to talk about him here. They're trying to introduce, I always think of myself as the best looking guy. It's no secret. I love beautiful women. That's why I bought Miss USA and Miss Universe. I love being around beautiful women. I mean, who doesn't? These statements have no admissible purpose at trial and only serve to attempt to portray President Trump in a negative light. I mean, come on. Can't beat up on the guy for that. Come on. The court should require the people to disclose a realistic exhibit list. They just give us a bunch of garbage. And so the people should be precluded from offering these exhibits at trial in order to disclose more information to us. So for all these reasons, Trump's defense says President Trump respectfully requests that the court exclude the foregoing evidence and the argument. Signed by Todd Blanche and the rest of the Trump defense team. Now, in all likelihood, my friends, a lot of this is going to be denied because I think this case is going to be as rigged as the rest of them in New York. And I think CNN agrees with that. This is a little bit of some reaction from them. Former prosecutor is saying that a lot of this is not, I think, going to have any merits because, well, we're in New York. It's Judge Juan Merchan presiding, and we know that he's already made some pretty adverse rulings against Trump by holding this trial so quickly. Now, here is some conversation from CNN.
Cohen from Testify?
No, that is a ridiculous request. They have to know that if you have a witness who you think is impeachable, has lied or will lie, the answer is he gets to take the stand if one party chooses to call him, and then the other party gets to cross-examine him vigorously. And then it is up to the jury to decide whether they believe or disbelieve that witness. There is no such thing as a judge saying, I don't believe this witness, I think he's going to lie, therefore he's off the stand. The DA is going to call Michael Cohen. They will assume all the risk that comes with that, but it's up to the jury, not a judge.
Yeah, and that's why prosecutors generally don't call those people because they are so lacking in credibility. But we don't really care about that. Like, we know the jurisdiction here is going to convict Trump because they've done it twice before in E. Jean Carroll. I mean, it wasn't a criminal conviction, but in the E. Jean Carroll case, we saw they went hog wild and found him liable for the grab him by the purse problem, the DJ diddle. But remember, the jury didn't even find E. Jean Carroll credible in New York because they found that she was a liar as it relates to the grape, the old hibbity dibbity. So that was, the jury found, like, we don't believe you. She said, I got hard in the dressing room. They said, no, you didn't. You're a liar. But we'll say, okay, maybe we'll give you a second one and we'll hit him with the grab him by the purse situation. So we have that one. We have Tish James and Engeron. We saw that whole scandal and that saga unfold. And so trial in this case is starting March 25th, my friends, 2024. We're going to be here covering it. So thank you for subscribing and joining us. There's going to be a lot more filings to unpack here because it's going to heat up and trial is going to start with jury selection. And I think that they're going to do everything they can to keep this thing on the tracks because it's their last gasp to get a conviction before the election. So don't forget to check out some of the links down in the description below. RobertGouveia.com is where you can get the PDF we just went through. We also have WatcherLodge.com where we're doing self-development and sovereignty stuff. Ton of fun there. And of course, WatchingTheWatchers.locals.com where we do members-only streams in the morning and shows on Saturday. And we'd love to see you join us so we can stay connected. And we'll see you back here on the next one.